Longjup, Longjup, Podumumi, Hatipara Forest Village, bracket close, comma, Longjup, Jaroni and Borapani Bagan, comma, Nagaon district. And what is this aspect pertaining to national food security?
My lord, the ration cards, my lord, and the other benefits, my lord, which were initially given. Now, though this, my lord, benefit has also been stopped, these categories of people who are sought to be.
This is a separate cause of action.
But
Where have you made the food and civil supplies a
no, my lord,
party?
because what has happened, my lord,
This will be done by the food and civil supplies. You have not made them a party.
my lord,
A right to education, where is the education department? Panchayat, where is the PNRD department?
my lord, Panchayat,
Because this direction is to be issued only to them only.
my
So we take out this thing.
lord, we,
Now I say that
my lord.
you submit that you don't want to insist here,
Yes, yes.
but if need be, liberty is given to
My
you.
lord, my lord.
Full stop. The petitioner also have
It is
sought for directions that a respondent should provide benefits to the petitioners under the National Food Security Act 2013, comma, Right to Education Act 2009, and the Assam Panchayat Act 1995, and all other necessary benefits. Full stop. This court inquired with Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioners. In respect to the prayer pertaining to seeking directions in respect to the National Food Security Act 2013, Right to Education Act 2009, and the Assam Panchayat Act 1995. And he submitted that the petitioner would be well advised to not to insist the said prayer in the present proceedings, and if there is any violation to the said statutory said provision, the provisions of the said acts, the petitioner be given to agitate the same by way of a separate writ petition. In the backdrop of the above, this court therefore takes up the instant writ petition only on the question pertaining to the challenge to the notice dated 8/12/2025 issued by the respondent authorities, as well as the eviction which is sought to be carried out by the respondent authorities on the basis of the impugned notice dated 8/12/2025. The case of the petitioners herein are that they have been residing in the villages of Longjup, Podumoni, Longjup, Podumoni, bracket Hatipara Forest Village, Longjup, Jaroni, and Borapani Bagan in the district of Nagaon for many years. Full stop. It is claimed by the petitioners that the original patadas, through lawful and valid means, have granted the petitioners permission to reside upon the said lands and cultivate the lands. Full stop. On Where is the notification? Notice, impugn notice?
My lord, the page number, my lord. Annexure 10, page 257, my lord.
On 8 to 2012, 2025, notices were issued by the Divisional Forest Officer, Nagaon Forest Division, to the various petitioners. Full. The petitioners apprehend that on the basis of the said notice dated 8/12/2025, the petitioners would be evicted, and as such, the petitioners have approached this court. This court have heard the learned counsels appearing on behalf of the parties, including the counsel who appears on behalf of the Forest Department. Mr. D. Gogoi, the learned counsel appearing on behalf of the petitioner, Forest Department, submitted that the said notice was issued in pursuance to directions passed by the learned division bench of this court in the judgment dated 18/8/2025, passed in writ appeal number 251/2025 and writ appeal number 252/2025. He further submitted that the said judgment was appealed against, that he further submitted that against the said judgment passed by the learned division bench of this court dated 18/8/2025. Appeals were filed before the Supreme Court, and by an order dated and by the judgment dated 10th of February 2026, the Supreme Court disposed of those appeals by issuing certain directions. The learned counsel further submitted that in view of the said observations and directions made by the Supreme Court, you may have to issue a fresh notice now, because your notice was based on that. The Forest Department now would take steps in accordance with the said directions passed. Full stop. These are reserve forest.
My lord, it is their claim, my lord. Yes, my lord. In the reserve forest, they are settling as a Tongia settlers, my lord.
No, understood. But are you admitting that these are reserve forests?
My lord, in this case, we are admitting.
This court inquired with Mr. A.R. Bhuiya, the learned counsel appearing on behalf of the petitioner, as to whether the lands in question wherein they are occupying fall within the reserve forest. The learned counsel submitted that the lands under their occupation fall within the reserve forest, but they are protected, being forest dwellers in terms with the Scheduled Tribe and Forest Dwellers Act.
There is a particular kind of
Cultivators.
cultivators called Tongia.
Tongia cultivators.
They are not there. Tongias are different. They are used by the forest department for a certain period of time to cultivate some grow forest.
No, they say that they were allowed by Pattadas. This is the stand here.
No, no. Against this Tongia, we maintain a register. We maintain a register. That is they say they claim as a patta. The approachable fine, reflection of that is the fine. 0.7.
No, that is his submission.
Not
No, the Supreme Court order.
That is his submission. I know that, no? He claims to be a forest dweller. Are you not?
My lord, we have initially, my lord, we were given the Tongia settlers, my lord, and then, my lord, we have purchased land from some of the pattadars, my lord, of the strength of that, we are residing there in, my lord, in those patta lands, my lord, because within the forest
But
area.
how can a reserve forest,
That is the issue, my lord.
you can purchase a patta?
My lord, because the original landholders, my lord, were the pattadars. From them, it is still in the name of those original pattadars.
In reserve forest?
Some areas are there. That's why, my lord, then
Those have, after the moment it is declared under Section 3, they don't have any right.
my lord, but those pattas have not been cancelled, my lord, and the
Whether it is not required to be cancelled.
My-
By declaration of law, it has.
My-
If it
that-
falls under the reserve forest, it is goes.
that is correct, my lord. That is correct.
So your benefit, there are two ways by which you can get benefit.
My-
First are scheduled tribes. Scheduled tribes, whether you are just in the forest, that is enough.
Enough, my lord.
You don't need any further thing.
My lord.
But forest dwellers, they can have to prove that they come with the 3 generations were there.
75 years, my lord.
This is the only way out.
My lord. Those things will place before the
No,
committee.
understood. So what is your case now?
My lord, our
But if
case
you
is that.
put that, for me, immediately I should dismiss it.
No, my lord. Our case is that, my lord, we are the Tongia settlers, my lord.
You are entitled for settlement where? How? In a reserve forest.
No, we are entitled for the settlement, my lord, as a Tongia settlers, my lord. Even the forest department, our Tongia settlement has not yet been cancelled, my lord. That is the issue. That concept is still persistent.
All these are Tongia.
My lord,
Okay.
my lord.
The learned counsel for the petitioner submitted that the lands under their occupation,
My lord.
no doubt, are reserve forest, but they were issued settlement certificates for temporary settlement under the Tangia system
My lord.
in the year 1974, isn't it?
My lord.
TONGUYA/TANGIA system. Putstop. This court have duly perused the judgment of the Supreme Court in the case of Abdul Khalik and others versus State of Assam and others, dated 10th of February 2026. The Supreme Court categorically observed in the said judgment peruse the sphere. Pustap. A perusal of the said judgment reveals that while those appeals were pending before the Supreme Court, an additional affidavit was filed on 18/1/2026 by the state of Assam. The contents of which were reproduced in the said judgment. The Supreme Court, further, at paragraph number 12, delineated the various policy decisions, the policy decision of the state of Assam to remove unauthorized occupation from the reserved forest. First of all. In addition to that, the Supreme Court also observed at paragraph number 13 that the state that on behalf of the state of Assam, the learned Solicitor General had assured that the mechanism evolved by the state shall be complied with objectively and with fairness while taking action for removal of unauthorized occupation in the reserve forest. First, taking into account the said, this court finds it relevant to reproduce paragraph number 12 and 13 of the said judgment in the case of Abdul Khalek and others, supra. First, it is the opinion of this court that in view of the observations made by the Supreme Court at paragraph number 12 and 13, the instant writ petition can be disposed of in the similar manner, thereby directing the respondent authorities to carry out, in terms with the directions passed by the Supreme Court at paragraph number 12 and 13, in the case of Abdul Khalek and others, supra, as quoted herein above. Accordingly, the instant writ petition therefore stands disposed of, with a direction upon the respondent number 12, upon the respondent authorities, more particularly the Forest Department, the Revenue Department, as well as the District Administration, the Forest Department, the Revenue Department, the District Administration, as well as the police authorities who are parties in the instant proceedings to comply as per the directions passed by the Supreme Court at paragraph number 12 and 13. First. Okay.
Till this status quo,
Supreme Court gave the status quo.
Yes.
Why do I need to give a status quo? I make it clear here. Mr. A.R. Bhuiya, the learned counsel appearing on behalf of the petitioner, submitted that some form of interim directions may be given. Full stop. This court have duly perused paragraph number 13. No, full stop. At paragraph number 13 of the judgment of the Supreme Court in the case of Abdul Khalek and others, supra, the Supreme Court had categorically mentioned that that the parties are directed to maintain status quo in respect of the land in occupation till speaking orders are passed. So similar directions, therefore, the petitioners, therefore, would be also entitled to is also entitled to a similar direction to the extent that the parties herein shall maintain status quo in respect to the land in occupation unless and until the compliance in terms with paragraph number 12 of the judgment passed by the Supreme Court is not complied with.
Highly obliged, deeply obliged.
In Abdul Khalek Supra is compliant. You give the details, how many, all are same village?
Milord, same area, same village.
All Tangia?
I have given the repetition after also, Milord. Obliged.
In fact, my lord, had made a statement that originally they are not given settlement. They have bought those lands from those original partners.
I have not touched the merit.
Why?
It is already given.
Obliged.
এটা line আমরা এটা লিখি দিওঁ, হা। This court have not decided on the merits of the interstate claims while passing the instant order,
Obliged.
which shall be decided by the committee to be constituted as per the judgment of the Supreme Court.
Item 4. Obliged.
Yes, what is this? Why should we interfere?
They are violating my rights.
You go to the GMC and GMDA. They are more helpful. Why you are not going to them? They have issued a notice to show cause. Where is that notice? Let's see.
The notice is at page 88,
Huh?
page number 88, annexure 14.
88 documents asking him. 88. Whereas you have carried out erection of illegal construction of a godown with deviation as specified and without permission for deviated portion as required by portion or so and so. Area by the master and zoning regulation, you direct to remove or pull down the so and so, and is asking for documents was served upon you and accordingly reply has been received, it is not satisfied. Yes, now what is this? For?
Under the GD. They are requiring the permission under the Municipality Act. We received the notices on 19/12/2025. Thereafter, we have submitted our reply. In 2 days, we took time for submitting the reply in annex 70, page 91. We have submitted our reply in detail. Thereafter, page number 95, annexure 18, they issued a demolition notice.
Then?
They are saying that we have not filed, no reply. Notice.
No, there was earlier, the reply was sought for.
Yes, we have submitted the reply.
Page 77, documents asking notice, complaint filed.
And we have
Then
submitted the
town
document.
planner, you have submitted representation illegal and arbitrary sealing out godown. Your godown has been sealed.
No, that is the temporary set. Now they are.
Then on 17/1/2000, I do not find any explanation as demanded above. Is the explanation here illegal construction of the godown on 17/1/2025?
On-
Page 83, clarification to your notice. Then
Exactly,
31/2025,
our
illegal
reply.
construction of building and temporary sheds at the backside of the godown of Hotel Rituras. Oh. Then
Our contention is we have building permission under the Gauhati Development Authority.
Then
They are demanding the permission under the Municipal Act.
Guwahati Development Authority, there is a permission
Yes.
under the 1978 Act,
In 1968,
68.
yes.
Where?
In
Page
6, annexure 1,
36.
annexure 1.
Reference to application for permission to erect a 3-storied on the Kedar Road of so and so, sanctioned for the aforesaid corner under the bylaw number so and so, subject to. What is this? Subject to following conditions.
Subject to following points. Type copy.
What is the following condition? 3-parted margin. And where is your sanction plan?
No, we don't have the sanction
Then,
because we purchased the land
no, hardly matters.
in the year
2 copies of approved drawings. Where are they? Where are those?
in the year 1968. We purchased the shed from our.
And Mr. One more thing. I'm asking you, here you have an assessment being made. Double story, so and so, so and so, so and so.
In
Now
60,
tell me, Mr. Bora,
Huh?
this building has been constructed as it is from then, 1989. It is being carried out.
in 1968,
Huh?
in 1968,
You purchased in 1989. When did you purchase?
in 1969,
No, you did not purchase in 19. You are not there. It has been sold. What is your name? Purana.
Surana,
Then?
1989,
Huh?
1989,
15th July 1994.
and actually 3. Hmm?
Is there any construction after 15th July 1994?
No, there is no construction. We purchased from our vendors as it is.
Now, what is the complaint? A complaint letter has been received from the regarding
That-
illegal construction of a godown. To submit the no objection approved plan occupancy certificate up to date text received and NGO received for remand and hence. Then what happened? What is your reply? Most preferably, I have purchased the land measuring so and so Iman and one part of so and so from one Gitarani Ghosal, and this property was purchased by on the basis of NOC and the permission you had the above Iman. Stated that on the basis of the fresh assessment, I paid the rates up to Iman. The go down required minor inlay like changing the teeny. Who are these people? Sanjay Kuchere and all these people.
They are our neighbor. Manager of
If the building is already in existence for all these ages, why are you troubling these people? Is the GMC hand in glove with the Sanjay Kucheria? We issue notice and the interim order which is passed is extended till disposal of the writ petition.
on 2nd February, they came for demolition of my house.
No. There's a, in spite of the interim order.
Yes. On 2nd of February,
Huh.
more than 60% came to demolish my house. Yes, sir. In spite of stay order, they came to demolish my house.
Then, how do I know?
No, in my godown, they came.
How do I know?
My client checked from me. And after showing the order,
They left.
left.
Then there is nothing. They didn't know. Most probably Mr. Borap must have forgotten while going out.
Maybe.
Okay, we issue notice. Issue notice making it returnable on 22nd of April 2026. What is your hotel name?
Hotel,
And why is the manager doing this?
he is doing on behalf of the hotel.
Mr. Bora, something very wrong. Huh? No. You see, the petitioner is the owner of the Rituraj Hotel.
Manager of the
Who?
Petitioner is
I'm
not.
I'm not
Hey. No. Wait. Ask the senior one to say.
my
You take care. Ask him to say. He's also there in the matter. Then, this is the respect you are showing.
My lord.
Mr. Moore, let me tell you. Petitioner appears to be the owner.
No, petitioner is not the owner of the Ritu.
Who is owner?
The owner is I know that I have no instruction. Who is the owner?
Huh?
But the manager of the Rituraj Hotel made complaint.
No. Who is the owner of Rituraj Hotel?
I have no knowledge.
Now, why is the
Some
petitioner
shortcut.
before this court?
Someone is Duggad is the owner of the
Huh?
someone name is Duggad. Title is Duggad. He is the owner of the Rituraj Hotel. And I am the owner of the adjacent plot of the hotel. And over which the structure
But where is your permission? You see, here somebody has submitted a reply. Where is that? Here. So you have opened a godown.
Yes.
You have opened a godown.
My-
Now tell me, Where is the permission for the godown?
Go down in the page tier one, and tier one.
Let's see. Where is the godown permission? This is a 3-story building.
3-story building plus.
Then where is the godown? And a Assam type godown in
And-
accordance with the plans.
Yes.
Assam type. So this Assam type godown is there. Now, how are you the owner of the godown?
Go down is standing over the premises which.
Now, has
I
the
have
godown been sold to you?
my lord,
Huh?
page 73, my lord.
No. Before that, let us see. Somebody sold, Gitarani Gosal have sold this land to Kamala Devi. Yeah, this is the sale deed. 89. Let us see the schedule. 89, what is the sale deed? Let's see. One Katha along with 3 Sridhar and 1 Assam type godown. So this was sold in 1989 to you. Then, what is this 94 sale deed?
The 89, 1969, it was sold to me and one HUF.
Huh? This sale
HUF.
deed is made with whom? Gitarani
To
Gosal
petitioner
to
and Manakchand.
Kamala Devi Surana. You are not Kamala Devi Surana.
I'm Kamala Devi Surana, and also there is one another name. Manakchand Pawan Kumar,
Huh?
HUF.
No, that is a subsequent sale deed.
No,
Manik Chan Pawan Kumar.
has sold it at page 39, my lord.
What 39? Mr. Bora, tell me what is this? Very difficult.
Page 73 is the deed. There is another. They also there is a go down.
This is being sold to you
First,
by some Manik Chand Kumar.
no, before that, the
Oh,
But-
both of you are not clear with your
no, my
facts.
lord. I'm
No.
just,
I
page
think we
number
should
41,
dismiss
my lord.
it. We should dismiss it.
My lord,
You
page
are
number
not
41.
being able to make this court understand the facts. I see a sale deed of the year 1969.
69. It was just sold.
89.
And
It's a fraudulent sale
Pawan
deed.
Kumar. There was in 1969 I purchased and along with
Where?
page number 41.
Okay.
Kamala Devi Surana.
You were the and so
And
and so. Okay, the
Manik
HUF purchased.
HUF.
Then HUF sold
and
it to
sold
you.
his share, yes.
So therefore you become the owner of the 3-story building plus the godown.
Godown.
So this is how it is. Now therefore why is Rituraj complaint?
Rituraj is adjacent to our plot.
Then
And the manager of Rituraj made a complaint. Complaint copy was never provided to us.
it is given there. Page 41. Page 77.
77. But the complaint copy was not given.
Page 78.
No, my lord.
A complaint letter received from regarding so and so, you are requested to submit no objection so and so, your reply should receive. Eh? Rear setback 0, side setback 0.1, so and so. You are asked to maintain a setback of 3.
My lord. That was the temporary structure. Which
No. Kindly see.
that
There
was
is
a
a
letter
no,
was-
Mr. No. You see, you are 3 feet clear margin on both sides of the proposed building and maintained from all floors. See your permission at page 34.
My lord.
So then why you are having less?
No,
It's 3 feet. Okay.
I have then a detailed reply.
Yes, why you are entering into the dispute
Page
amongst
16,
others? You
84.
have better things to do, na? Huh? Do something. Let that Kucheria come. Huh?
Page 85, alia is a notice was given. If I schedule of violation, then demolition taken place. Which is the right now the he challenging the notice, order dated 16/1/2026.
Hmm.
Earlier it has been there and it has been demolished.
Hmm.
They justify it is the earlier method.
So this has been
It
demolished.
has been demolished. That's notice in some different manner. Now it is challenging in page number 95. Next slide.
So here the entire godown is being challenged here. But godown had a permission.
Not to bucket happened, the only thing is that he gave a reply. Well, later was not taken into account in the reply is definitely not beyond the 7 days period. After the 7 days period,
It is not in the interest of GMD or GMC to do other civil litigations for them now. Or have you become the settling authority? Eh? Mr. Esbora appears on behalf of the respondent number 1. Extra copy of the writ petition be provided to him. As regards the respondent number 2, the petitioner is directed to take steps by way of speed post by tomorrow. The petitioner herein is aggrieved by the order dated 16/1/2026, whereby the Commissioner GMC had ordered the petitioner to pull down the unauthorized construction, that is, illegal construction of the Assam type godown. The learned counsel appearing on the petitioner drew the attention of this court to the permission granted to the predecessor in interest of the petitioner by the then existing Gauhati Development Authority dated 29/11/1968. He submitted that in terms with the said no objection granted at that point of time, the petitioner was not only permitted to construct a RCC 3-storied building for commercial and residential purpose, but also an Assam type godown. The petitioner, isn't it?
My vendor was permitted. My vendor.
Mr. Moore, did you listen what didn't I say? The predecessor in interest, isn't it your vendor? Then, full stop. Subsequent thereto, the predecessor in interest of the petitioner sold the particular plot of land along with the building and the godown to the petitioner and one Manak Chand Pawan Kumar HUF by the registered deed of sale dated 25th of October 1989. It is the further case of the petitioner that subsequent thereto, the said Manak Chand Pawan Kumar HUF transferred his share to the petitioner in respect to the land, the building standing thereon, as well as the Assam type godown. He therefore submitted that as there was a permission as far back as in the year 1968, the respondent herein could not have passed this order, impugn order dated 16/1/2026. Mr. Moore, the learned counsel appearing on behalf of the petitioner, further submitted that this is a case where the GMC authorities have taken certain action at the behest of the respondent number 2, which statutorily they have no business to do so. He therefore submits that this is an action on the part of the respondent authorities which suffers from malice in law, and therefore it is a fit case where the impugn order dated 16/1/2026 is set aside and quashed. This court have given an anxious consideration and have perused the materials on record, and is of the opinion herein that the petitioner herein is entitled to certain interim directions. Accordingly, till the next date, the impugn notice or order dated 16/1/2026 shall remain stayed. Further to that, there shall be a maintenance of status quo in respect to the land as well as the building, including the godown of the petitioner, till the next date. খুব একটা উইথড্র করবি বলেছিল না? Yes, you want to withdraw?
Item number 6.
You want to withdraw?
Yes, Lord.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that he would like to withdraw the instant writ petition. Mr. B. thus appears on behalf of the judicial. Taking into account the above, the instant writ petition stands closed on withdrawal.
Item 7.
What is this?
This is also the eviction matter well filed
Huh? Forest?
forest man,
Forest?
forest.
Same order?
No, my lord, actually,
They are also Tongya.
we have allotted the land. Cannot only see the page 21.
Is that a reserve forest?
Legally constituted village there, we have been given land
By?
by the, my lord, can you see?
Now, is it a reserve forest or a village forest?
It's a forest, village. The forest where they reside in a entity called Forest Village and they are Tongyas.
Then?
Then,
Name?
our
Yeah,
right
the,
is
it
protected by
is
the,
Udmari Tongya Forest
yes,
village. Jamuna Circle and so Forest Division. Okay.
my lord,
So
can
it
you
will
see?
family dispose of.
The-
Same order, same order. This court is
My
not
lord.
going to do.
My lord, can you see?
You are protected by the Supreme Court. I am also protecting you. What more do you want?
One miscase is there.
For
One miscase for correction of, my lord, can you see?
correction
Order.
of what?
Correction or wrongly inserted another name in place of mine.
Advocate, he was the advocate, but wrongly.
Wrongly.
Mr. Vina's name was recorded because we were okay.
It's okay. Here, your name will be put in golden letters. Yeah, naam to bhai dibo, huh? A.J. Atia. Bold.
Item 20 after that matter.
May I please, sir.
What is your case?
Your lordship will find the last page 11. They have brought into
Page?
the notice of
Of
the IA,
which IA?
1429.
388. I have only two IAs.
There are two IAs.
One is
one is disposed of.
3367 and 388. Which one?
This is the latest IA, there are 1429. 388, sorry, your lordship. 388. It has been wrongly written down in the above. Your lordship, what had happened in this matter in the last occasion when the IA was disposed of, the alia IA, they have brought into the notice of the court,
State a further
have withdrawn
operation of the
notice that we are
improved
challenging.
notification dated Iman issued by the Iman directing the heir to vacate the land and stop illegal construction on the applicant's land and compensation. Now, what do you want here?
Now, lordship, what had happened?
First, what is your case?
The case, your lordship, you find your lordship at page 15. The eviction notice has been served upon.
Main writ petition.
the
Main writ petition, I look into IAs later on. First, what is your case?
that we are challenging, your lordship, has already been withdrawn by the respondent side. The notice that we are challenging was already been withdrawn.
Quashing the
Now they
impugned
will-
demarcation notice
Yeah, that is also there.
issued by so-and-so directing the respondents to vacate the demarcated land and stop the illegal construction on the petitioner's land. Huh? Where's that notice? 24/6/2025?
That is disposed of in the IA 33.
This is to inform you
67.
that the demarcation of the land below will be carried out on so-and-so. You are therefore directed to present personally on so-and-so. Where's the demolition?
The lordship will find in that the.
No, Mr. Counsel,
Yes, sir.
first and foremost, you have to understand.
Yes.
For filing IAs, you have to have the edifice.
Yes, sir.
Where is your edifice? Or I may say it, the foundation.
Yes.
Foundation is what? Mr.
Lordship will find at
Tutia,
page
kindly tell
43.
me. If
43
you have
of the
challenged the notice
For demarcation.
for demarcation, which obviously the court should not pass any order, but anyway, you have withdrawn it. Does anything remain, cannot initiate anything on the basis of the IA?
Demand has not been withdrawn, my lord.
And then,
That there is a not, demarcation notice was issued on 24/2026,
Ah.
25, my lord. Petitioner LCL death demarcation notice in the petition, my lord.
then this is 25. Page
25,
40.
my lord.
Ah.
Death demarcation, that was salient before this honorable court.
Then,
And my lord, the claiming that the petitioner has the plot of land, that is another plot of land.
Ah.
So the petitioner does not have any right on this particular plot of land.
now has the demarcation been carried out?
Partition. Or my lord, that has already been carried out, my lord, because it is a 2025, my lord.
Ah.
Now, my lord, after 2025, notice, eviction notice was issued to the petitioner, my lord. That subsequently, that notice was returned, that notice was issued under Rule 80. Rule 18 is not applicable, so that notice was issued. So there is a dispute between the, my lord, petitioner and another persons and about the land, my lord. So lordship has disposed of the writ petition with a direction to approach the Secretary Revenue Department and review and as the.
So the
Also, my lord,
dispute is between petitioner and some other person.
also, my lord.
But is there any dispute with you?
My dispute between the petitioner, another person and occupying the government land also. So
But both are government land.
my lord,
Is the petitioner occupying government land?
government land is also, my lord.
No, lord.
my-
No. This is a Miyadapati, his
So
own,
that
your
is the,
lordship.
my lord, that is the-
21 bighas of land he had. Out of the 24 bighas, 5 bighas of land he has given to the government for 4 lane. For that also he have received compensation in regards to this.
So what is your dispute with whom?
We are dispute with the respondent side, your lordship, because with the aid of the respondent side, the other side has come into the place. And they have
He
constructed.
has?
they
Other
have-
side has?
Has come over the place of trespass my land, and they have constructed the kacha house also therein. And the notice has been issued by just changing the dark number and path number and targeted our plot of land. And they are ready to demolish the house, there in the plot of land, the shops there is in the plot of land, they are ready to demolish by tomorrow.
But who is ready to demolish? They.
The number 3 has passed.
Who is they?
Respond number 3,
Who?
the Principal Secretary Karbi Anglong Autonomous.
Okay. So they are interfering in a private dispute between you and somebody else.
No, it's not a private dispute. They have themselves have issued the demarcation.
It's the council.
Yes,
You have a dispute with some A
yes,
who is not a party here.
yes,
Now they are interfering in that dispute.
yes,
So that is, make that submission.
yes, Lord.
Yes, Mr. Sutia. Is that the so?
The factual part, my lord, there is a limited question of facts are there.
No, understood. No, understood.
My lord,
Only one fact I want.
What?
Whether the dispute is between petitioner and some A.
my lord, dispute not like that, my lord. As part of my lord, Karbi Anglong transfer of land, my lord, for transfer of land, permission of the executive committee is required. If without taking permission, if the petitioner obtain the land, my lord, and fraudulently obtain the pata also, the autonomous council have the right, my lord, eviction, my lord, as per section 5 of the Karbi Anglong Transfer of Land Act, my lord. So my lord, at this stage, my lord, that day before yesterday also Supreme Court passed the order that regarding the adequate opposition to adduce evidence. This case also, my lord, dispose of a direction to the secretary to approach the Secretary Revenue Department along with all these documents and for a period, within a period of specific period, and till that there will be no eviction.
You're
There will be
happy?
no eviction, my lord.
But you have been evicted.
No. Dated tomorrow.
No, there will be no eviction tomorrow, my lord. First, will recognize statement on basis of.
I give him time to submit a representation within
My lord,
15 days, 30 days.
And thereafter 30 days, my lord. And what, my lord, so.
Within
what-
15 days, you submit your representation
Yes.
before the Karbi Anglong Autonomous Council.
Department of Revenue, Karjalang Autonomous Council.
Which one?
Is the offer.
To the respond number 3.
3.
And then the respondent number 3, you may have to issue a notice upon the other person na,
My lord, all the persons who have.
who are interested, to all the interested person, and then dispose of as soon as possible. Till the disposal, he is protected by speaking order and giving him another 15 days.
Yes.
There will be no,
Yes.
But as the word used by the Supreme Court to adduce evidence, my lord, whatever evidence he may.
Now, he may appear, which you see, well, how does they, whether, how does he want to do that is his
My
lookout.
lord, I am submitting it the other cases, my lord. In all the cases, other cases are also coming. That order is the party land particulars, but as the Supreme Court used the word adduce evidence, so I am submitting it that.
No, it's okay. No problem. So we passed that order?
My lord.
Yes.
Okay, let me come back. But your problem is this eviction is sought to be done on the basis of IA. How do I take note of that? Luckily, you have a very good opposing counsel. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears for respondent number 1. Mr. J. Hendrick appears for the respondent number 2 and 7. 7 also. Mr. J. Sutia, the learned standing counsel for the Karbi Anglong Autonomous Council appears on behalf of the respondent number 3 to 6. The petitioner claims herein that he is a lawful pattada and possessor of a plot of land measuring 21 bighas, 2 kathas, 10 lechas, situated at Kaliram Bosti, Khotkhoti, under Moza Borzan, patta number 2, dag number 16, in the district of Karbi Anglong. On the said land, the petitioner is carrying on a business in the name and style of Alok Brick Bhatta since 2011. On account of construction of the 4-lane road, the petitioner had shut down the said Bhatta in the year 2018, but regularly paying the land revenue. The petitioner had also received the compensation in respect to the 5 bighas of land which have been acquired and the remaining 21 bighas and remaining 16 bighas, 2 katha 10 lechas still remain under the possession of the petitioner. Full stop. A demarcation notice was issued on 24/6/2025, whereby the petitioner was asked to be present when the demarcation would be carried out by the LR staff on 26/6/2025 at 10 a.m. The petitioner, being aggrieved, had approached this court by filing the instant writ petition. The materials on record show that this court, by an order dated 1/9/2025, issued notice full stop. At that relevant point of time, as there was no interim relief sought for interim directions. No, full stop. No, ঠিক আছে. Had issued notice by an order dated 1/9/2025, issued notice. It is very pertinent to take note of the order dated 1/9/2025, wherein the learned coordinate bench have duly recorded the objection of Mr. J. Chutia, the learned standing counsel of the KAAC, to the effect that the petitioner claims to be the owner and possessor of dag number 16, whereas the demarcation notice is in respect to dag number 142 and 168. Full stop. The record further reveals that the petitioner thereupon filed two miscellaneous applications. The first application was filed on 16th of October 2025. Seeking a stay to the demarcation notice dated 24/6/2025 and the eviction notice dated 10/9/2025 issued by the Assistant Settlement Officer / Assistant Revenue Officer Karbi Anglong. It is very pertinent to take note of the notice dated, eviction notice dated 10/9/2025, wherein there is a reference made to the land covered by dag number 168 of periodic patta number 66, which is recorded in the name of Protima Timungpi. And the petitioner was accordingly issued the notice as per Rule 18.1 and 18.3A of the Assam Land and Revenue Regulations of the settlement rules framed under the Assam Land and Revenue Regulations. The second application which was filed by the petitioner is for stay of the eviction notice which was issued on 29/1/2026 issued by the Secretary, Department of Revenue, Karbi Anglong Autonomous Council. Wherein also the reference has been made to dag number 168 of patta number 66 of an area of land admeasuring 2 biga 4 katha 19 lechas. Full stop. This court have perused the pleadings, and the petitioner have not given any justification as to how the petitioner is affected by the said impugned notices, taking into account that the dag number mentioned in the said impugned notices is dag number 168, whereas a patta number (66), whereas the petitioner's landholding certificate as well as the Jamabandi for the surveyed village, both dated 11/1/2024, enclosed as Annexure Roman 1 and Roman 2 to the writ petition, refers to dag number 16 of patta number 10. Full stop. This court heard the learned counsel appearing on behalf, also heard the learned senior standing counsel of the Karbi Anglong Autonomous Council, who submitted that instead of pursuing the present proceedings, the petitioner ought to have approached the respondent number 3 by placing the necessary materials which would show that the petitioner have any relation with dag number so-and-so or patta number so-and-so and have any claim over the said land. He further referred to Regulation 5 of the 63 and submits that the respondent authorities, the Karbi Anglong Autonomous Council has the authority to evict such petitioners, such persons who is in unauthorized occupation of land belonging to
And the tribal people.
of the tribal people.
Title district transfer of land act 1959.
59. Huh? Gusto. Taking into account the said submissions, it is the opinion of this court that the petitioner should therefore approach the respondent authorities. Mr. J. Sutia, the learned standing counsel, further submitted that if the petitioner approaches the respondent authorities within a reasonable time, that is 15 days, the respondent authorities are not adverse to taking into consideration the petitioner's representation along with any evidence placed, thereby justifying his right to remain over the land and passing a speaking order. So taking into account, so this court, having heard the learned counsels appearing on behalf of the parties, is of the opinion that the interest of justice would be met, that the petitioner be given an opportunity to submit his claim before the respondent number 3, and thereby directing the respondent number 3 to pass a speaking order and thereupon to proceed in accordance with law. Accordingly, the instance with petition stands disposed of with the following observations and directions. The petitioner herein is given a period of 20 days from today to submit a representation before the respondent number 3, along with all necessary documents which should show that the petitioner has claim over the land in his possession, as well as having and as well as that he has also any right over dag number 168 or patta number so and so, which is the subject matter of both the demarcation notice as well as the eviction notice which have been issued against the petitioner. The respondent number 3, upon such application representation submitted within the time so permitted herein above, shall pass a speaking order after intimating all interested parties in respect to the claim of the petitioner. Footnote number 3. This court further directs that till such speaking orders, that this court further directs that till such speaking orders are passed and a further passed, no steps for eviction of the petitioner shall be carried out. So it is further observed that in the circumstance, the speaking order is not favorable to the case of to the petitioner, a further 15 days time be given to the petitioner before initiating any steps for eviction.
The eviction may be protected for both my original Patta land also. Because the eviction notice has been given in regards to Dag number 168.
Mr. Counsel,
Yeah.
first of all, how many years of practice you are having?
11 years. 11.
Start preparing a petition properly. If this matter would have come up for motion and Mr. J. Sutia would not have made that suggestion, I would have dismissed your petition.
Lordship,
What type of petition is this?
notice has been issued into.
You don't know what you are mentioning. See your petition, read it, it starts and finishes. On a lighter note, it reminds me of going to a particular place in, what do you call, Teju. I think this must be around 2011. So it was not so developed. So I asked, you don't get good hotels or anything out there. So I asked somebody, tell me which is the best hotel. So he said that, okay, you go to this particular hotel. So the hotel was such that you start, the moment you enter, the room you enter, it finishes. His petition is somewhere like
It
that.
was not drafted by me or
Whoever it is, you don't draft it. You got the best order out there. Yes, Mr. PD Nair.
Please, Your Lordship. So pursuant to the last order, my lord, I have filed an additional affidavit drawing the comparison between the.
I asked you that.
My lord, the additional affidavit is there, my lord, from
Your
page
file.
256, my lord. Similar duties, my lord, in my lord, from the High Court, the Civil Court rules and orders, have annexed Rule 836.
Yes.
From page 256, my lord, is my additional affidavit, my lord. I've relied on the Civil Court rules and orders, my lord, of the Gauhati High Court, Rule 836. I've extracted that from page 257. And I've summarized the functions at page 259, paragraph 5, my lord. That says, page 259, my lord, right up to paragraph 5 of the additional affidavit. Case management, my lord, supervision of work, personnel and establishment matters, official correspondence and liaison, assistance to the district judge, and general administration.
So here it is more.
Similar, my lord. Similar. My lord, there are two documents. Next, my lord, page 264 is a letter from the Deputy Secretary to the Labor and Employment Department to the Registrar of Labor Court, Dibrugarh, about the duties and functions of the Registrar Labor Court and Industry at page 264, my lord. And page 265, my lord, is a document by the signed by the presiding officer of the industrial tribe, delineating my duties and functions.
When did he give? Yes. Mr. Arbor Pujari, what do you have to say?
The duties and functions have been demonstrated there. Otherwise, so far as the definition of the finance department is concerned, we say that these are two posts are not equal. Number one, the post of CEO, the promotion and post.
Now, how do you take care of 37/2012? The notification of 37/2012, which changed the entire complexion of the case.
The relevant portion is at page 79. The aforesaid benefits can equally be applicable to staff of corresponding grade and status working in various court class or industrial tribunal. Now, here we say, in our affidavit, the sum and substance is that these two posts are not equal. Now, here the penalty is second.
No. When you are equaling, we'll look into that. You see, in pursuance to the letter of the Supreme Court so-and-so of the subordinate courts in Assam and approved in the tribunal in exercise of the AR of 300 and in exercise of powers conferred by Article 309, the governor is pleased to extend the following benefits to the non-judicial of the subordinate courts with effect from 1/4/2003. The financial benefits recommended in the pre-revised pay scale shall be given to the pre-revised so-and-so. So these are the benefits given under 309 of those rules. Then what has happened is you have inserted here the aforesaid benefits shall equally be applicable to staff of the corresponding grade and status work in the various clothes like MSCT, so-and-so, so-and-so, so-and-so.
Tribunal labor court.
So therefore, when he has given this particular, that is why I say, although his affidavit in reply was not so clear on that aspect, so I've asked him to file an additional affidavit. Now, in the additional affidavit, he gives it that what are the duties of the registrar? What is the registry of the registrar? He says, although Mr. Nair doesn't want to say, but as it appears from there, that the work of the registrar is much more than that of the registrar.
But there has to be a I will be relying on Bihar itself.
The Bihar has been taken care of by this because of the government having accepted it.
Therefore, it is subjective. This is not objective. Let me read it, my lord. It says, my lord, the aforesaid benefit shall equally be applicable to staffs of corresponding grade and status working in various corresponding grade and status. Now, CEO is a post which is a promotional post. It is the highest post in the ministerial hierarchy in subordinate post. a person gets inducted into service, he goes on, and he is promoted. There is a case where it is a case of direct employment.
Does he have a promotion?
He will have a promotion. So
Then-
therefore,
That is also the highest post.
maybe, but mode of recruitment itself is different.
So what?
Then how mode of.
But no, mode of recruitment is different, but but your state of Assam has done this.
I have done this, madam, because
State of Assam equates services under the MSCT with that of that. Now, with these and coupled with the judgment of the Supreme Court in that case, where is that case where the Supreme Court says that they also come within the ambit of the High Court under 220?
My lord, Gujjar.
Huh?
My lord, RM Gujjar versus High Court of Gujarat.
draft high court. Supreme Court,
No. The Supreme Court judgment which was passed by, I think, Justice Rumapal, I suppose.
My lord, Sujata Manohar.
Ha, Sujata
My lord,
Mohan.
1998 2 SCC
1990,
680.
whereby it says that they also come, although in my opinion they could not have come, but this is the judgment. And thereby what has happened because of their judgment, they come within the ambit of a 235 rules because of their judgment.
No difficulty, but whether it is a corresponding grade, that is what is to be examined by this court, in my respect on something. This is the qualifying words here, types of corresponding grade and status. As per the ROP rule, the grade and status doesn't correspond, number one. Number two, this is the promotional force.
No, as per the ROP rules, you have not put them at the same grade or status. That is why the petitioner has approached this court.
Therefore, madam, subjective, people is, madam, I don't think, but my.
Obviously, that is why I am sitting here.
So my submission is my, since the treatment should be fine, they are minor, they kind of.
No, that would have been taken care of unless you disown this 37.
I cannot be wrong.
No. So therefore you cannot distinguish. You cannot distinguish on the basis because of your acts. You see, that is a judgment. In Bihar, what has happened, these are different. Bihar, where there were two sets of teachers. One set of teachers were appointed in a different manner regularly, and the upper where some scheme were there and all these things were there, so they continued to. So they are asking for the same equal pay because they were doing all the work. The courts looked into all these things. There are two judgments out there. But a concurring judgment refers to, but the main judgment doesn't say. You have to also understand. This is another very interesting thing. When there are two judges sitting, maybe a division bench, when the senior judge writes it, unless it is being authorized, the senior judge's judgment is the main judgment. And here it became the main judgment of Justice Lalit. It is only in the concurring judgment of Justice Sapre who has said all these things. Justice Lalit doesn't say anything that Jagdish Singh is bad.
Fine, madam. Then, so that's the authoritative part, madam.
Does it in the paragraph number 98 and 99, does it say about this?
So the idea, my God, part of the government, which has been offered, my God, but here, they are not to find, my God, the principle of equal pay and equal work has been filled up, and, my God, there has to be an identity. Both
The
sides-
identity, therefore, he has the judge has concluded at paragraph number 99, I suppose.
There's been, my God.
But tell me now, these two petition, that question I will allow it. My question is therefore, next is, I will allow his petition, but the only question now is this. The equation would be made by this court as on date, equal pay for equal work. Then in that regard, there will have to be certain directions passed for the changing into the, for the making changes in the ROP quadrant. So it will be prospective.
Madam, for giving it the benefit of equal pay, it will entail minor interference in the ROP.
Understood. ROP interference will happen.
Whether minor
No, when the adjudication is being made today, that it is, they should be entitled to equal pay for equal work. If this court passes that order, then would it be a case of area payment or prospective?
One of my,
once your person tells that they are doing equal work, we can on the scene. Then when equalization occurs. So when equalization occurs, then definitely, substance it will.
Then where do you stop? No, therefore the question is, where do you stop? Would you stop at the stage of the petitioner becoming a registrar? Or where? Because the petitioner may have become a registrar when?
long, my lord, he was appointed in 1996.
As registrar,
Yes, my lord.
1996. So therefore, it may go to the date on which the ROP comes. Or is it from that date equation? Because the equation can't happen unless, because if I'm making the 37 2000
2012, my lord.
as the basis,
My lord.
it can't go prior to that.
My lord, it was 1/4/2003, my lord, the 37.
Mr. Bobidari, think on that.
Here is a different statement of the state of Haryana versus Pilapla at paragraph 19.8. It was an idea, but as we said, thus in state of Haryana versus Pilapla, it was told that the principle can apply only if there is complete and wholesale identity between the two groups. Even if the employees in the two groups are doing identical work, they cannot be granted equal pay if there is no complete and wholesale identity. Example is given, when the daily rated employee may be doing the same work as a regular employee, yet he cannot be granted the same pay scale. Similarly, two groups of employees may be doing the same work, yet they may be given different pay scales if the educational qualifications are different. Also, the pay scale can be different if the nature of jobs, responsibilities, experience, method of recruitment, etc. are different. Therefore, we say that the CEO with their promotional post, currently reaches that level. He has the experience, substantial experience. There is a case model where he is directly recruited. That issue of experience is different.
So if there is a direct recruit and if it's a promotional recruitment, then it would differ. Why?
Therefore, it says, paragraph 27 of Tilakra book will refer to paragraph 94 of Bihar. Now, Tilakra second, in the set of equals, held that the principle can only apply if there is complete and wholesale identity between the two groups. Even if the employees in the two groups are doing identical work, they cannot be granted equal pay if there is no complete and wholesale identity. Example, a daily rated employee may be doing the same work as a regular employee, yet he cannot be granted the same pay scale. Similarly, two groups of employees may be doing the same work, yet they may be given different pay scales if the educational qualifications are defined. Full stop. Then says, also, pay scale can be different if the nature of jobs, responsibility, experience, method of recruitment, etc. are different. Now, moving further, my lord, differences also be made, my lord, versus state of Jharkhand.
Yes, why the Supreme Court did not explain on this aspect? Direct recruit and promotional recruit.
But then Supreme Court
They
said,
could have given that, because the recruitment will be different also. Maybe a recruitment which is by way of a proper selection process and without a proper selection process. Because the reference or the metaphors which are being given out there is in respect to a daily wage with a regular person.
it says, but in our opinion, this is which from the as is, I'm trying my best.
You try your best. I'm also trying my best. I'm my AI is very open. It never closes till it does.
Why not from S6 under state of Jharkhand, 2007-86-79. It says, madam, in our opinion, fixing pay scales by courts by applying the principle of equal pay for equal work upsets the high constitutional principle of separation of powers between the three organs of the state. Realizing this court has in recent years avoided applying the principle of equal pay for equal work unless there is complete and wholesale identity between the two groups, and there too, the matter should be sent for examination by an expert committee appointed by the government instead of the court itself granting higher pay. It has been held that this is a concept which requires for its applicability complete and wholesale identity between a group of employees claiming identical pay scales and the other group of employees who have already earned such pay scales. Article 14 permits reasonable classification based on qualities or characteristics of persons recruited and grouped together as against those who are left out. Of course, the qualities or characteristics must have a reasonable relation to the object.
But there are many judgments of the Supreme Court on the question that as when it comes as regards a challenge being made, as regards a certain promotional quotas are being affected and all. So then being made by the promotees when they are challenging that our promotional quotas are being affected by giving this 25% direct. I think these are matters which are there where I think this must have been there in the All India judges case also, because there was a 25% direct recruitment and 75% belongs to this promotion. So there was a challenge to that. So there the Supreme Court says that you cannot equate the promotional, you cannot, or if you take away more, then there will be a problem because they have the experience and all. This is another line of thought.
Now,
But one thing, Mr. Barbujari, let us read Justice Sujata Manohar's judgment. Because for me, I'm still having very difficult to consume that. Because what is happening, why I'm telling it, what is the problem which, if you are saying that you still have the control of the disciplinary or anything or the service conditions of these subordinate officers or staff of the MSCT, then how would the judge who is the head of that department or who is the head of that MSCT have a control over these people? Tomorrow, the driver may say that I am not coming. I've taken the ear from Mr. Arbor Pujari, who is the secretary or somebody. No, this is a very, because Section 7A or Section 165, before 65, 165. 7A of the Industrial Dispute Act and 165 of the Motor Vehicles Act empowers the state government to form these, appoint these, to set up the labor court, industrial tribunal, as well as also the MSCT. So therefore, these persons concerned are to be appointed as per their qualification. which again comes back to what I was saying earlier. And the state needs to appoint them. Because it is not the High Court. High Court has no business out there. It is the different thing that the state may have surrendered the role to the High Court and asking them to look into it, and the state will give the appointment order. But in the process of selection, even a High Court judge can be selected to be MACT and so and so. Later on, there was an amendment that were bringing the district judges also within the field of for recruitment. Now, if that be so, on what basis? If the High Court controls have the power under 235 against these officers, and the state does not, then in that regard, how the presiding officer of the labor court or so and so of the MACT would have a control over the subordinate judiciary?
My respect to submission, whether can it be a determining factor for the purpose of my lord?
No, because you see, on one hand you are saying that look here, these appointments we make, they come under transport department or whatever may be. They have our own department out there, the labor department where we are bringing him. We don't then bring them. Our ROP does not bring them within the judicial department. So therefore, you are saying, then it's very difficult to have both together, taking into account that it will have an impact on the very functioning of the MACT. Taking into account the High Court has, on the administrative side, has been appointing them, okay, he will go to MACT, he will go to do so and so, so and so. What is being done out there is this. Just for example, in MACT, there is no further order required. But if it's just for example, in Sirang, let's take the example of Sirang. Sirang doesn't have an MACT tribunal. So what happened? The district has become then, and there is an additional power given by the state that he will function out there. Because of that, he exercises the power of MACT. So therefore, if that be so, in respect to a district, it is okay. District judge is so he has a control over his people. But here you say that they have no control then. Even a leave is not required to be taken from him.
Employer.
No. Therefore, if you are saying, if we are to accept this, I have to go further to that aspect.
But there is, my lord, there is another aspect, my lord. If my lord comes, it's too.
But on the other hand, although you are saying all these things, the recruitment, all these things, only one thing gels with me is regards the promotional aspect, and direct recruitment aspect may be another aspect by which they may not get it. That is may only be the consideration which may be. Otherwise, by way of this notification dated 37/2012, whereby power is being exercised under 309, the governor makes these people a part of the subordinate judiciary and thereby bringing them under 235. So then if they are, then how can you regulate their terms and conditions in view of this notification? Mr. H.K. Das.
Verified department. Under what would be the consequences, implications of this last part, second paragraph? I can understand the previous period. Here the benefits have been come now. He will get these.
No, therefore, if you see, the moment they say that they will be a part of the subordinate judiciary, take that, bring the judgment of Justice Sujata Manohar, both together, and also see what is the problem which the functioning of the MACT or Labour Court would have if they don't have to report to the head of the MACT and say, no. Driver says that, no. My reporting authority is somebody, I've taken the leave. Court officer says that, okay, why should I be there? I'll take a leave. He would not know also. You don't need to even ask this person concerned that I want to take a leave. You understand the problem? What do you have to say? You are also the Gauhati High Court amicus curiae on infrastructural bench. Huh? How do you take care of this? This notification of 37 categorically says they are part of the subordinate judiciary. See? MACT corresponding grade and working in various courts like MACT, so-and-so, Labour Court, Eastern Assam Court in Assam, which falls within the sweep of the subordinate judiciary. Now, if it falls within the subordinate, 235 is attracted.
My lord, another aspect. My lord.
Please.
My lord, page 252, if my lord. wants to
Yes,
come.
please. I am always at here to give you 252.
This is a notification, my lord, of 28 May 2024.
Invest additional
which-
powers of the presiding officer of the industrial tribunal as labor court here for adjudicating judicial cases of cases.
AC. No, additional level. Ago additional level. Ago.
Now, what is happening is this. This is again another notification issued. Without this notification page, kindly say page 252.
Ago.
It seems here the judicial department acknowledges 252. The judicial department here acknowledges that the industrial tribunal and the labor court are separate. Okay. But brings the civil court as well as the MSc together.
The governor of Assam needs to invest additional power to the presiding officers of the industrial tribunal of Kamruk Metro. This is what I was about to spell out.
But this is being done under section 165(3) of the MSCT Act. You see, for adjudicating not judicial cases, but to MSc nature, this power is to be invested under 165(3).
Infrastructure.
So under 165(3), that power is being invested upon him.
This to because of infrastructural difficulties.
Whatever may be. Now you see the next line in that. Further, the services of officers and staff of the Industrial Tribunal and Labour Courts of Assam may be utilized in the process of adjudication of judicial cases of other civil courts and civil nature, including in the existing infrastructure. So this power is being given in that court itself. Where is this? Kamrup Metro.
All fine. Kamrup Metro, Kachar and Dibrugarh, industrial tribunals. As well as the labor courts
Yeah,
of
but as
Kamrup
long-
and Dibrugarh.
as long as there is no presiding officer in the labor court, so far as Kamruk Metro is concerned. The Ghana district judge is officiating as such.
How? Now you are doing it.
Therefore, my lord, for administrative.
Now, for that, a specific power has to be given. Because the tribunal to be set up under 7A is different.
Then the, for the,
Ah.
that in contravention of the original statute. But that if at all that can be done.
Now, in fact, what is happening, it appears, unless Justice Sudhakar Mohanohar's judgment is because you bring them within the ambit of subordinate judiciary.
why not accept that also subordinate judiciary? Suppose they come under the subordinate, can why not the functional, why not the aspects of the matter has to be looked into? Because
The only thing which is appealing is he is a direct recruit, whereas those are promotional. That is the only aspect, because promotional has years of experience, which is not available for a direct recruit.
some managerial activities, supervisory activities, some minor quasi-advisory activities. So,
Register.
no, but so far register or that post is CEO is concerned. He has to deal with everything, man.
He deals with many things. It has been given by the industry.
The highest ministerial in the court, for a timing letter scheduling. Now, in a subordinate court, the CAO will say, and similarly, so far as industrial tribunals are concerned, which are options of the statute that is the industrial dispute act. Here, my lord, the highest ministerial staff is the register. Now,
Yeah. Shestada.
it says that in register, in the register. So there, he says, my lord, that there is no post of register. It is the highest postman. So for the ministerial staff are concerned. From him, it goes down. Then subordinate judiciary CAO. So we keep CAO here, we keep the registrar here. Now, whether CAO, so far as lordship inference is concerned, my lord, but it was drawn an inference that if we attach 235, it both come under the same thing. But at the same time, my
But that cannot be done. So that notification may also not be proper.
now, so far as registrars are concerned, this emanates from an altogether different statute, which is the IDA. And so far as CEO is concerned, it emanates altogether from a different source.
So therefore, who is to appoint the presiding officer? The government. The High Court has no business even to transfer. Unless, let's see Sujata Mano as Justice Sujata Mano.
Problem consequences perhaps because of the reason that due to lack of adequate manning power, the district judges have been allowed to function in some places. Then people just stop.
No, you see what happened.
Because
Even a labor court. No, the reason is because the state is trying to save the money. The state is trying to save the money and therefore they are not appointed. Just for example, a CAT. In CAT, a person has to be appointed. He has a tenure. Now, this particular tenure is a tenure. Here, you don't have even a tenure. So, is the central government made any rules on the tenure, on the industrial rules, dispute rules, on the tenure, the terms and service? Something has to be made somewhere. No? That means a person, let's see where the industrial dispute comes out. Or even the MACT, is it being made? Motor vehicle has MACT. Oh, MACT to Assam has made the rules. Assam motor vehicles rules.
Months of applications.
Oh? At last. No. I have already drafted the judgment. It is ready. It will be delivered. Only one fine point was missing. How to take care of that application. Then I thought of, which you'll be knowing it. In fact, I told it on that day also. This application, which is filed belatedly, would be taken as a reminder upon the claims tribunal to ensure the obligation as to whether the DAR is filed or not. And if it is taken as a reminder, the proceeding again will start. I think this is the only way out. You may file after 4 years also, whatever may be, you may file, but it will be taken as a reminder. As regards, because otherwise, what happens? 149 says, upon information received from some far or from the claimant or from any other source, he is to make an offer for before the tribunal. The tribunal will inform the claimant taking up this money they are offering. If he does not, the tribunal will raise the case and hear on the enhancement of the compensation. First set. Second set comes in when the tribunal, when FIR is being filed, within 48 hours, it is the mandatory duties to submit the FIR. As per Rule 18, the moment the FIR is being filed, a miscellaneous application will be drawn up, proceedings will be drawn up. Now, R has to be filed within 50 days. That will be again put it out there. And then the DAR is to be filed within 90 days, which will be put in that miscellaneous application. Then there will be a direction to the investigating officer, kindly bring the claimant. Now, the moment the claimant appears, it will be registered. Okay. Now, therefore, if a person files at a later point of time, under 163, it will be just a reminder that these actions have not been taken. Huh? It appears to be, that seems to be the only way out. Huh? This is the only way, because otherwise you cannot say that no, because there are some people who may not. But it is, because the entire proceeding process, it's a way beautifully it has been taken care of. That is why they removed this. Because when I was taking bench one, I had the option of, I could see it. 8 years, 10 years down the line, they are filing applications. In the meantime, the insurance company doesn't have any document. The police doesn't have any document. And they say that police case is this. Police cannot search it. Somehow they get hold of a particular FR is being given or whatever may be that the person could not be seen. And on the basis, insurance can't make out where is the car even. Because they didn't make any investigation. And this becomes a huge problem. And in fact, yesterday, the Supreme Court, I think Justice Amanullah was looking into this bogus or the racket in respect to claims being made under the motor accidents tribunals, which is happening. All these fake documents are being prepared. So this will stop. Anyways, let's come back.
My lord,
Complicating the agencies.
Huh?
During the mischief, as well as my lord putting the agencies that you have to perform
Yes.
your obligations.
Now that is why while taking up the matter, I asked Mr. Dinath to appear and he got that notification out
Yes.
by the Home Department that if you don't do it, disciplinary proceedings in. So on the basis of that, you can ask that here that kindly report it to them for initiating. Then once one or two cases happen, things will move.
strictly.
Yes.
Okay,
Madam
now
had
let
made
us
it
see
very-
here the industrial rules, central rules.
My lord, there's a notification annexed to the affidavit by the High Court, my lord.
Just
wherein-
1 minute, let us see the industrial
My-
dispute central rule. How will these people be there? Service of summons, description of cases, powers and reconciliations, so proceeding people, area court, evidence. Proceedings. Here. Traveling allowances. The chairman or a member of the board or court or presiding officer of so and so, if not official, shall be entitled to a fees. The chairman of a member of a board or a court, the presiding officer so and so, wherever he is not a salaried officer of the government may be granted such fees as may be sanctioned by the central government in each case. You see? But, there is a possibility that he may be a salaried officer of the government also. Industrial Disputes Central Rules 1957.
But
32.
Another one, my lord.
Ah.
They have annexed to their affidavit, my lord, page 160 onwards.
Of the- which
Presiding
aff-
officer of labor courts, industrial tribunal and national tribunals, salaries, allowances and other terms of conditions of service. 2015.
160.
Starts, the English version starts at page 160. My lord may come to page 161. Lordship was inquiring about the duration of the term, my lord.
Uh-huh.
Rule 3.
Okay. This is a central government. These
Central
have been done recently.
My lord, 2015.
Okay. So, the pay of the presiding officer of the national tribunal shall be 80,000 per month, and this shall include the deputation allowance in case of serving judges, and gross pension is so and so. The salary of the presiding judge of a labor court, the district judge entry level is so and so, district judge selection level is so and so a year per month, inclusive of gross pension. Now, what is the period?
Rule 3, just above that, man.
Rule?
3.
Ah.
Duration.
You see, this is the thing. Now, in case of appointment or deputation of serving judges as presiding officer, the normal period of appointment shall be for a period of 3 years. And in case of retired judges, the appointment shall be till the age of 65. It is similar to labor. Presiding officer, labor courts, industrial and national so and so allowance rules. This is done now. Therefore, so it's like a temporary post, like a cat.
Term post.
Cat, I think cat is also 3 years of.
3 years or 65.
This cat is 3 years. No, I think more. 3 years.
3 years. Earlier it was 5 years, 5 years.
Earlier.
After the last rule, 3 years.
Earlier,
5.
5 years term, then extension, so reconsideration and extension.
no, earlier it was 3 years at one point of time. That I know it personally. Yeah, I know it. That is 3 years. Thereafter, I think it was increased. Sometime after, in around 2000, 2001, it may have been increased. And now it is 3 years and 65. And it is 65. So it is something like same to this effect. So therefore, a presiding officer has to be sent on deputation.
Yes. I have annexed one order also.
Let's see how they are sent. Huh?
One of the order can be. A serving judge can be appointed on transfer of deputation by the retired judge can also be appointed on re-employment basis. Notification by Judicial, Labor and Employment.
On deputation. So therefore, this judge has to go on deputation. No, he has to go on because he is not in any longer in the judicial department or in the services of the High Court, under the High Court. He may be, but it is something any other. Let us take any other officer of a minister's type. He may go to another department. I'm saying, let's the case of any deputation. A person concerned in one office can very well be deputed, sent on deputation in another place for 3 years, which is the normal period. So therefore, it appears to be 3 years there or till 65 years. And they may say 65 years taking into account the High Court judge aspect is one of the qualifications. So 62, then 3 years becomes 65. Because the district judge normally would be 60 plus 3 years, 63. So he may be appointed after that as a so and so, a retired district judge. But as regards, but here it says, and in case of retired judges, the appointment shall be till so and so. So if he's a retired, if he's a district judge who is retired, he can be there for 5 years. So if this is a case of deputation, then which appears to be what I also think it is a case of deputation, then obviously it is separate from the district judiciary, completely separate from the district judiciary. So that notification which was issued of 37/2012 appears to be without proper application of mine.
My lord,
Against my significant because lawsuit is now looking from the employer and the lawyer. The health is the I'm reading it my estimation is 7A. Because this is the draft of the my lord.
Yes.
The appropriate government may by notification in the official gazette of schedule one or more industrial tribunals for the adjudication of industrial disputes relating to any matter, whether specified in the second schedule or the first schedule, and for performing such other functions as may be assigned to them under this act. The industrial tribunal constituted by the central government under subsection 1 shall also exercise on and from the commencement of the Finance Act jurisdictions, powers and authority conferred on the tribunal referred to in section 7B of the Employees Provident Funds and Miscellaneous Provisions Act. Now, my lord, the qualification. The tribunal shall consist of one person only to be appointed by the appropriate government.
So the appointment is by them.
If the person shall not be qualified for appointment as the presiding officer of the tribunal unless he is or has been a judge of the high court or
So therefore they make it 65. A high court judge, sitting judge can also become, and a retired high court judge also can become.
of not less than 3 years, being a district judge or an additional district judge. Then my lord, he is or has been a deputy chief labor commissioner central or joint commissioner of the state labor department, having a degree in law and at least 7 years experience in the labor department, including 3 years of experience as conciliation officer. Provided that no such deputy chief labor commissioner or joint labor commissioner can be appointed unless he resigns from the service of the central government or state government, as the case may be, before being appointed as the presiding officer, or he is an officer of the Indian Legal Service in grade 3 with 3 years experience in the grade. The appropriate government may, if it so thinks fit, appoint 2 persons as assessors to advise the tribunal in the proceeding before it. Now, my lord, if lordship says, my lord, 7A3, 3, my lord, so 3 subclause A. Now, so far as my lord, the judge of a high court is concerned, it is stated, my lord, he is. Meaning thereby a sitting high court judge can also be a presiding. But so far as my lord, recruiting a district judge, sitting district judge has not been given that, my lord.
For a period not less than 3 years, being alia. But if you see 7B, 7(3)(b), you see they are referring to Deputy Chief Labor Commissioner Central or a Joint Commissioner of the State Labor Department having a degree of law. Now, if you see the proviso that no Deputy Chief Labor Commissioner or Joint shall be appointed unless he resigns from the central government. So it is a permanent for him. It means he has to go there. There is no way out. But here, number C is, he is an officer of the Indian Legal Service in grade 3 with 3 years of, what is this Indian Legal Service? Have you heard of?
Applicant, my lord, in the year 2017.
No, this was brought in 2010.
This came into being by way of an amendment, by Act of 2017, with effect from 26/5/2017.
Which one?
This,
No, no, not this one. Only that the industrial tribunal shall consist constituted by the central government comes in. But as regards that 773C, that must have come at the time when the NJAC was holding the thing. No? At that point of time, it was going on. So they were having contemplating Indian Judicial Legal Service. So that is why they must have brought in it. That one.
effect from 2010, yes.
So therefore, the question is this. Now let us see Justice Sujata Manohar's judgment.
My lord, since my lord is on the act, my lord may see the Assam amendment also.
Where?
My lord, in the act itself.
Oh, in there. Yes.
In 7A, in subsection 3, after clause A, insert the following clause. Dr. Francis. He has worked as district judge or additional district judge, or both for a period not less than 3 years, or is qualified for appointment as a judge of the High Court, provided that appointment to a tribunal of any person qualified under this clause
Or shall not be made without consultation with the Assam High Court.
with the Assam High Court. And coupled with that, my lord, the Assam Judicial Service rules, my lord, which have been annexed, my lord, to the affidavit of the High Court. There, in the cadre of grade 1, in the presiding officer of the Industrial Tribunal and Labour Court are included, both in the 2003 rules as well as in the 2016 amendment.
Where?
My lord, in the affidavit filed by the High Court, my lord, if my lord comes to page 200, Schedule A,
200.
200, it starts at 200, Schedule A. Grade 1 officers are mentioned, my lord. Lordship may come to the next page, 201. Serial number 10 and 11. Presiding officer, Industrial Tribunal, and presiding officer, Labour Court. They are included in grade 1 of the Assam Judicial.
But this can't happen.
The rule says
No, no. Can you make a rule?
What?
Because you see, if you see the proviso to section 7A also, which have been added in Assam, it only says about with consultation with the High Court.
yes, ma'am.
The consultation may be in parameter A with 235, but
Yes.
not 235.
Not 230. That I understand. That I understand.
But for all said and done, it has to be a case of deputation. If it is, therefore, let's see Justice Sujata Manohar's judgment. How do we take care of that? If it is a case of deputation, then it becomes very difficult for him. And that is your thing. I'm not on that establishment. But the thing is, if it is a case of deputation, it is a clear different thing. It is a tribunal which cannot have the encompasses of the court, which is completely different. So therefore, when you are having the presiding officer there, otherwise the problem is, if the presiding officer is a part of the state, then he has a say over him, the employee. You see, why I'm saying, the moment the presiding officer is a part of the state department, then this person has to report to him. Now, just for example, tomorrow, you see a peon being done by any person, by the presiding officer taking an action or disciplinary action is being taken. It cannot be taken by him unless he becomes a part of that judicial department or that If he is brought under some judicial service rules, it's a different. He has to be deemed that he is gone on deputation. Otherwise, he would not have the control over his entire establishment. No, tell me.
Control. A different thing altogether. Vis-a-vis what has been discussed here. Because here we are concerned with right pay.
No. You see, the thing is like this. Mr. Borpuzari is saying that these persons have been recruited by the labor department. Isn't it?
Maybe.
No, wait. Whereas these persons are brought under the judicial department. The head registrar. They belong to the head registrar. Now the question arises, the moment I hold, yes, they belong to the labor department, then how do you take care of? They are two different cadres. First of all, you have to also understand that these are statutory tribunals constituted under these acts, Industrial Tribunal Act or the Act. Now, if these acts are being made, now whether there is a corresponding provision of under 165 for the recruitment out here in Assam, in the Motor Vehicles Act, so is there any amendment to that effect with consultation?
My lord, I'll have to check.
Because we are discussing on the industrial tribunal. We have case of industrial tribunal,
Industrial,
not MACT.
not it.
Okay, then there is no problem. So therefore, let us not go to MACT then. So therefore, here is a case. Would the presiding officer have a control over his establishment? No. This is a very important thing. Now, if he belongs to the judicial service and not on deputation, he would not have control. Please.
I don't know how far it will be proper to look into that. He's from judicial department, he's from legal department. But the fact remains that in that particular office, presiding officer is the boss. And that-
How?
and
How will he be the boss? How will he be the boss unless he's on deputation? Unless there is an appointment to that effect. Here it's only a consultation under 7A. You see, the appointment has to be made on the basis thereof, as per the rules made in the year 2015.
whatever, he is the presiding officer of that particular tribunal. He'll have to have disciplinary control over the
How?
his subordinate official.
No. Mr. Das, why I'm saying so is this. I've seen a first-hand problem with this. The state of Nagaland, they gave us the judicial officers. Nagaland Judicial Service, judicial officers. You have all the judicial officers. But kept the ministerial staff. Did not transfer. So what happens? This person concerned said, okay, I take a leave from somebody. He doesn't know anything. So therefore, this establishment has to be meant by the person concerned, or this subordinate staff or the ministerial staff has to be brought under the person who is manning this establishment. Huh? How? You see, unless it is an appointment by the government, how will a person who is under Assam Judicial Service be brought in here?
Presiding officer, MSCP, and industrial tribunal, all are catered for in the Assam Judicial Service rule.
How? How is it possible? Because it is these are posts under the central government, under these acts, the central acts. This has nothing to do with this. Tomorrow you may Mr. Das, you can very well tomorrow in the Assam Judicial Service, you may put also the High Court Service also. But would it be possible override the statutory provisions of the Industrial Disputes Act as well as the rules framed under 2015? Just for example, in CAT, a High Court judge can become. So High Court judge, what he does, for me, I go to CAT now. After 3 years, my period is there, I come back. Would I be permitted to be a judge here? You see, why I'm saying, you see, one has to, while dealing with this very aspect, I have to look into this. His basic case, which I have also recorded in the earlier order, is the notification dated 37/2012, where the governor has said that he falls within there. The judiciary is a subordinate judiciary. So therefore, I am insisting, let us see how Justice Sujata Manohar
My-
takes note of this aspect, so that it may give some
My lord,
glimmer of hope for this court to decide
my lord may come to para 5 of the
of
of the judgment. My
where
lord,
that's
1998 USCC 680. A copy most probably
you have given many judgments with
1998 USCC 680.
1990. Got it. How
Para
is it
5,
being
my lord.
taken? 236. Labor Court judges held covered, hence their appointment has to be made in accordance to 234. High Court's decision setting aside the appointment of the Eastern Levy Commissioner as the High Court Judge April. Labor Court appointment of the judges of the year 234.
It may come to para 5, my lord. Para 5, my lord.
Not much of difficulty in holding that a labor
no
court
much-
function performs judicial functions and is a court. The labor court adjudicates upon disputes that has. Now, this paragraph 5, Mr. Borpujari, if you remember that judgment of the Supreme Court in 1969, which was referred to by you in those series matters, wherein the question arose as to whether a labor court would be able to entertain an application under Article 137. A 5 judges constitution bench said that no, they cannot, they are just tribunals. So under no circumstances the Limitation Act will apply. You remember that? But this goes a bit different here. The Labour Court adjudicates upon dispute that has not been for the Industrial Disputes Act and the so and so and upon him would have been within the jurisdiction of the ordinary civil courts to decide, although the ordinary may not have been that. In the so and so, this court considered whether Lina was a court, it was said that one cannot go by the mere nomenclature. One has to examine the function of the tribunal and how it is so and so. It held that as an industrial tribunal has all the trappings of the court and perform functions which cannot but be regarded as judicial. The court referred to the rules by which the rules by which were regulated. The court dealt with all the facts and powers of the so and so. The court dealt on the fact that the powers vested in him are similar to those exercised by witness, power of ordering civil so and so. By this judgment, they say that a labor court officer, a presiding judge, would come under Article 234.
Paragraph 5 would take paragraph.
And he goes through the first paragraph. With regard to selection, tenants, selection requirement, the post of presiding officer.
Understood.
Observations has been made
No, kindly come to this. No, if you see, what is being done is para 4, 6. Now, what has happened? The Supreme Court observed that as it has all the trappings of the court, it is a court. No, you see, and it goes further to say, therefore, it will be under 234.
Presiding officer.
Then the moment the presiding officer comes, the judicial department will also come in. Kindly see, therefore, 236 comes in. How do you come? How does the ministerial staff come under us? The only way is 236. Mr. Counsel, listen. How does the ministerial staff in the subordinate judiciary come before us, before the High Court? Tell me. By virtue of 236, isn't it? That's the good judgment. So what is the analogy given? The labor court as well as the industrial tribunal have all the trappings of a court. So therefore it's a court. And as such 234 comes in. By virtue of 235, 236A comes in. And if 236A comes in, therefore he gets the right to be, he becomes a part of the subordinate judiciary. He. Presiding officer is 234. You get the point? Because by virtue of good judgment, the Supreme Court says that even, which was taking into account the full bench of Madhya Pradesh High Court, it said that even a person who is working in the ministerial staff will also come by virtue of 236. So if 234 is the presiding judge, by virtue of 236 they will come in. And if they come in under 236, then why they should not be equated with him? Mr. Das, I am open-minded. It is not that I don't want to give it to the petitioner, but this is the thing. If they are in the subordinate judiciary under 236 or the ministerial staff, 236C, 235, provides that a control over the district courts and the courts subordinate thereto, including the post and promotion of or grant of leave to the persons belonging to the judicial service of the state. You see, 235 is judicial service, and holding any post inferior to the post of alia shall be vested in the High Court. Article 236A defines district judge including so and so, so and so, so and so, so and so. This is an extensive definition and does not cover every category of the district judge. While considering the application, one can also bear in mind that they have district judge so and so. This is 236. Now, what happens by virtue of 236? In Gujar's case, the Supreme Court said the ministerial staff read with 235, 233. 233 is district judge, na?
Yes. 33.
The district judge and 234 and all would come within the ambit of the 235. So therefore, they will have a control. If they have the control and the High Court, now you see, you have to also remember, Mr. Das, the High Court has the power, then would be assessing their everything. You see, I am a person who can, being a High Court judge, is in a position to assess what he is doing. Because he's under my control, under 235, on the administrative side. So therefore, the state cannot look into that. So if that be so, when the administrative committee recommends, here there is a recommendation of the administrative committee, headed by Justice Ansari, that if they are to be equated, then they are bound. In the overall situation, this is what appears from this. I'm open-minded. But this is what is a plausible argument in this aspect. Gujar. Because of this, although I have some difficulties in accepting, but I'm bound.
Is the main document.
The main document, thereby this is being recognized by them.
Lordship, whatever.
And therefore, I'm saying, why the presiding officer? Now, what is happening? Why I'm putting the question of presiding officer? There's a very definite reason. The moment it is being used in this manner, not as a consultation. Section 7A says about consultation with the Assam High Court. The amendment says with the consult, which is not there otherwise. Consultation of the Assam High Court is mentioned about this, but it is not a consultation which is actually happening. This person is being transferred and posted by the High Court, and they give the additional power. Now, therefore,
That I have annexed provides for notification I have annexed, it provides for sitting district judges also.
understood, but no.
That-
If a sitting district judge goes out there, normally he should go. Normally he should go on deputation. But here the consultation which is there in the proviso to section 7A appointment has been termed as if they will be doing it. How is a district judge being brought from, just for example, a Karbi Anglong district judge brought to MACT Gwalpara? How? How? How is he doing it? Not the power of the Chief Justice. This is done under by the administrative department. Administrative, because it's a full court. It is the High Court, not the Chief Justice who can exercise. It's a full court who can do it. So therefore, these transfers which are being done, it will be done by the full court. So therefore, this transfer goes there on that basis. And that the notification is issued. And it is not out here, not by the full court. What happens is the decision is taken, power has been conferred by the full court on the administrative committee, who will look into it. And they do it, and then it is being done. Now, state has no rule. So if can the state have no rule in view of section 7A? It has to. But if we read this with Gujjar, these persons will come. And this is being recognized by 37/2012. Chalo. We will hear again on the next date on the question of otherwise I'm satisfied. But this is any judgment you find any other thing, because this is a very certain things goes very much against constitution bench judgments. Because that is a 69 Supreme Court, 67 Supreme Court, these are all constitution bench judgments, which says something else. But anyways, even the judgment of the two judgments which goes from here. One is that what? The deputation. Mr. Das, 1973 or 71 judgment now, which went from here to the and it was taken up by the constitution bench. That matter pertains to what has happened. This person concerned went on deputation as the LR, and the Assam government was not releasing him. And when it was named, the High Court was asking, send him back. And the Assam government said, no, we want him. And he also wanted to remain in Assam government. And that led to an dispute which matter went to the constitution were referred to. It's a 1971 judgment.
Yes.
Now that is why I asked you.
Over the name, but I read it. Perhaps this in the Arunachal.
That is. There I have referred to how it is. So that is how it is. Anyways. All right. Who did it? Huh?
You go wherever, you get, again, you have to come back. You screen it.
So therefore, if you say that he is on, there are many aspects. Once you say that he is on deputation, very well, then he can control the establishment. You say that no, it is not required for him to do it. He will go there because the entire other set is also comes under 236. No problem. But if you say that he goes out there, other set is outside, which is the which is the claim of the finance, will have a huge problem later on. Because I have to observe something. Whether it is he, because it is his submission. So then I'll have to observe that the moment I do that, it will have far-reaching consequences there. Then this presiding officer may not able to control.
Control is a different thing altogether, and this parity is a different thing altogether. If my senior goes to control, then that thing.
So
will
if
be
he
drastic.
if he sticks only in direct recruitment and promoting, no problem.
That's the thing.
You stick to direct recruit and promoting. Huh?
Whether this one. Whether this,
I have also reservations with this judgment, but this is another way.
we have to raise the argument because of my lord, this 2012. Because 2012 notification has possibility to raise the argument. If it was not here,
No. You stick to the direct recruitment and promoting.
but because of 2012.
Hey, he's not making my job easier. Okay. We'll have it on some other day when it is very busy. Okay. 26th.
From this month.
Hearing remains in contest. Take whoever wants date, please take it. Any interim orders will be extended.
So,